Thank you for calling Come As You Are Community Development. How may I help you?
Come As You Are Community Development has dedicated its energy to helping people.
Hey Gus, how you doing?
As a matter of fact,
Good morning. Good.
Come As You Are CD is co-owned by entrepreneurs T.D. Jefferson and Jervis Williams.
Give them a call and give them the information.
Fraud by many of the big banks right after the turn of the century devastated the housing market and, more importantly, the American people. Because the devastation is so widespread, affecting so many people, Mr. Jefferson and Mr. Williams created a new branch to their company dedicated just to these victims of housing fraud. Welcome to Kaya Defense Network. And now, here's Kaya Defense Network President T.D. Jefferson.
My business partner and I are certified securitization loan auditors. We educated ourselves so we can better teach you. If you look at our webpage, Kaya Defense Network, the videos on that page, video 1 from MSNBC, the banks perpetrated the fraud on the American people.
Nothing yet, because what you're about to hear is both unbelievable and may represent the largest fraud ever perpetrated on the American consumer. 820,000 Americans have already lost their homes this year due to foreclosure by the big banks.
Video number 2 from CNN. The banks don't have the paperwork to prove it in court that they own it.
I think they can. In foreclosure, the bank has to show it owns your house. But what most people don't know is almost half the time, the banks don't have that paperwork to prove it in court. In many cases, it ends up lost or destroyed. It's a national problem that the banks would love to keep quiet.
Video 3. Since the banks don't have the paperwork to prove it in court they own it, 60 Minutes video. The banks are creating fraudulent paperwork to show ownership.
At some of these companies, a decision was made to recreate the documents. So these document mills sprang up, like the company called Docs, D-O-C-X, that we found in Alpharetta, Georgia. And what Docs was doing was creating tens of thousands of these assignment of mortgage documents.
That's why we have made it a passion to go out and educate the homeowner about their mortgage situation. And they need to know if they are a victim of that fraud.
This training is for new reps coming on board. In order to get the most out of this, you'll need the following documents: a copy of a note, a copy of a deed of trust, the service and transfer disclosure, a servicing coupon or payment statement. And you'll need to get a couple of forms from the attorney firm hired by the bank to foreclose on that person. From them, you'll need the acceleration of mortgage form and the notice of substitute deed sale. These are the items you'll need to actively participate in this training. Now, grab your worksheets. It's time to get started. And to do that, here's T.D. Jefferson.
In the worksheet, it states, a note is a contract to pay borrowed money. Once again, a note is a contract to pay borrowed money to who? To your original lender. It is a negotiable instrument governed by Article 3 of the Uniform Commercial Code, UCC. I want you to put parentheses around this part. The note by itself is an unsecured debt. This is an excerpt from an actual deed of trust. A. Security instrument means this document, which is dated, put the date that you purchased your home, together with all riders and documents. B. Borrower is your name, single/married person. C. Lender is your original lender. Now, if you look between B and C, what's highlighted there? Borrower is the grantor under this security instrument. That is very important. When your original bank paid your house off, your house was paid for free and clear. The original bank put a lien against your house. And they say, if you don't pay me, I'm going to take your house. And you agree to it in the deed of trust. That's why it states that you are the grantor under this security instrument. If you don't pay lender, they will take your house. Well, let's look at number 20. Well, the original lender is not the lender that's trying to take your home. Well, it's very important that you understand number 20 or number 19 in your deed of trust. This is an excerpt from the actual deed of trust, and you can look at your own deed of trust as well. Number 20. It's very important that you understand before we go here how banks make their money. Banks make money by selling the note. Do you have a dollar bill or any money, a bill? I want you to pull it out. On this dollar bill, if you read the left upper corner, it states that this note is legal tender for all debts, public and private. This note, money is just a what? Note. Green money is just a note. And this note is legal tender for all debts, public and private. When you went to the title company and signed this note, they made this note legal tender for all debts, public and private. The note with your signature on it, the promissory note. The banks make money by selling and lending money. The banks can sell your note. It's very legal. It's not against the law for them to do that because banks sell and trade money. But when they sell your note, this is what must happen. Number 20, sell a note. And let's read what's highlighted. The note or partial interest in the note together with the security instrument can be sold one or more times without prior notice to the borrower. The banks can sell your note 100 times without you knowing. They have a right to do that. But it's something very important in there. Note together with the security instrument. The bank can sell the note, but the note got to be sold together with the security instrument. When the bank sells the note has to be endorsed to the bank that purchased it. I want you to look at this endorsement on the screen. An endorsement is just like a check. I'm going to write a check to you. Well, when the bank sells the note, they got to sign it over to the bank that purchased it. Remember, when the bank sells the note and the deed of trust got to be together, and the note got to be endorsed. And the example of the endorsement looked like this. Pay to the order of whatever bank need to go in that blank without recourse from the bank that sold it. Now, if the note hasn't been endorsed, that means the bank don't what? Own it. The next step is assignment of note and deed of trust. Assignment is just like a car title. This is the way I'm going to make you understand this. If you sold me your car, you will sign over what to me? The title. Could your neighbor sell me your car? Well, let's just suppose your neighbor sold me your car. I paid your neighbor $20,000 for your car. You saw me driving your car down the road. You upset. He stole my car. Well, you call the police. The police come to me, and the police going to ask me for my title and registration. I give the police my title, and he sees that it is a good title. The police going to come back to you and say, well, sir or ma'am, he have good title. And you're going to say, that's impossible, because you're going to go back and get your what? Original paperwork. And when you go back and get your original paperwork, it's going to have the VIN number on there. It's going to have the date when you bought the car. It's going to have your name on it. Well, the police going to come back to me at this point and going to want to see my paperwork. Well, my paperwork was dated after your paperwork, which means you had the car first. Well, the police going to ask me who I bought the car from. And I'm going to say I bought it from your neighbor. Well, the police is going to go to your neighbor and ask your neighbor for the paperwork of where you sold the car to your neighbor. If your neighbor don't produce that paperwork, well, the police going to take your neighbor to jail. they're going to pick up the car back from me, and give it back to you, and I'm going to have to go sue your neighbor for my money back because you're not the person that damaged me. Well, it's the same scenario. Instead, it's your house, not a car. And you need to make sure, like on the 60-minute videos, on the assignment, this is the ownership paperwork that shows that they own it. Assignment of note and deed of trust. Let's read it. Assignment of note and deed of trust is just like a title. For every endorsement, remember when the bank purchased the note has to be endorsed. For every endorsement, there has to be an assignment of note and deed of trust. The note and deed of trust have to stay together. The note by itself is an unsecured debt. Some of the homeowners are not in foreclosure. This is very important. If it was me, I'm not an attorney. I can't tell nobody what to do or what not to do because we are not attorneys. But if it was me, I would do a qualified written request and I would tell the servicer that I'm going to pay my money to my own escrow account. When you release the paperwork showing that you own it, I will pay you. If the bank don't respond to me within 60 days, I will go seek an attorney and file a suit. If you read further down on the servicing transfer disclosure, look where it have damage and cost. Let's read that. Section 6 of RESPA also provide for damages and costs for individuals or classes of individuals in circumstances where servicer are shown to have violated the requirement of this section. If the servicer don't give you a response in 20 days, that's a what? Violation. Each violation has a damage and a cost. If a servicer don't give you a written request on each dispute, each one of those are a what? Damage and cost. If the servicer put it on your credit, that's a violation again because they cannot report it to the credit bureaus. That is a what? Damage and cost. In other words, we're going to educate you on how to get you pertinent information that will put you in position to settle. Settlement can mean a principal reduction. One of the reasons could be through damages and costs. Or it can sue for your house free and clear. I'm not saying you get a free and clear house, but if they give you information, fraud is in that information, fraud voids the contract. You will need an attorney to go settle for you. If the bank do own your mortgage, you owe that money to them. If they show the proper paperwork showing that they own it, the only thing you can do is catch it up or get out. Or if they don't prove that they own it, you have a right to fight for what's yours. Now it's time to get information from the attorney firm. Because the attorney that's foreclosing on you is a debt collector. And I want you to go to the document or the paperwork that we gave you, validity of debt dispute. Let's read the first part of it. It states, the FDCPA defines debt collector as a person engaged in a business with the principal purpose of collecting debts or whom regularly collects or attempts to collect directly or indirectly debts owed to another. Whether you fall within the definition is crucial. If you are considered a debt collector, you are subject to all the requirements and restrictions of the FDCPA. The attorney firm that is collecting from you, look at their paperwork. On their paperwork, it will let you know that they are a debt collector. By them being a debt collector, there are certain laws that they must follow. Let's take a look. I want you to turn to the second page of the worksheet. And let's go to this part. It's very important. The FDCPA also requires, and I have it highlighted, that a statement be included in the initial communication with the debtor, the homeowner, providing the debtor with written notice containing the following: the amount of the debt, the name of the creditor in whom the debt is owed, the statement that unless the consumer within 30 days after receipt of the notice dispute the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. The statement that if the consumer notifies the debt collector in writing within a 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of the judgment will be mailed to the consumer by the debt collector. Well, let's break that in part, because that's how you read it when you get that statement. But let's break it up, because it's very important. The statement that unless you, the consumer, within the 30 days after receipt of the notice, disputes, you got to dispute the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. The attorney firm is going to assume your debt to be valid. See, you skipped over that part because you were just reading it. But it's very important that you pause there. If you don't dispute it, that attorney firm is going to say this is valid.
You may also need to get some information on your state's civil procedures. This will help you understand the laws in your state. You can buy a book on this at your local bookstore, or you can go online to Google and put in your state name and civil procedures. And finally, you'll need to go to quickstudy.com and download a copy of the U.S. Constitution. That's quickstudy.com. Download a copy of the Constitution. You'll find you may be protected by the 14th Amendment. And remember, we're always on at KayaDefenseNetwork.com.
My people perish for the lack of knowledge, and it's up to me to educate God's people. Have a good day.
Come as you are, community development, helping people help themselves.